Good afternoon, everyone. Welcome to this webinar. My name is Mariolina Eliantonio. I am a professor of European and Comparative Administrative Law at Maastricht University, and I am one of the co-organizers of this webinar this afternoon, together with Dr. Marina Serrat, who is here on screen with me, who is an assistant professor also at Maastricht University. And allow me just to share my screen to kick off this afternoon on the topic of judicial control of administrative cooperation in tax matters, taxpayers' rights, and the notion of foreseeable relevance in the light of the Court of Justice case law. I'm very happy to have you all today, this is one of the events that I would like to, to see as a series of future events, seeing a closer cooperation, well, in Maastricht and beyond, between tax lawyers and administrative lawyers. I think that much of the discussion, for example, around the Court of Justice case law is very much proceeding in silo mode, and I think both communities would very much profit from exchanges with each other. And I'm very happy to have been able to cooperate with Marina today and to have a number of speakers from various corners of the topic to speak today. So the event of today, the webinar of today, is co-organized and co-sponsored by the Maastricht Center of Taxation, together with the Globalization and Law Network, of which I am the academic coordinator. And before I leave the word to Marina to kick off today's webinar and also to present a little bit the cases that will be at the spotlight of today's event, let me just say a couple of words on Globalization and Law Network. The Globalization and Law Network is an, if you wish, is an inter-branch group that we have created within the law faculty of Maastricht University with scholars from the various areas of the law. So we bring together private lawyer with public lawyer, tax lawyers, legal theorists, and so on, to study a number of phenomena that are brought about by globalization, in order to see what role law has to play in a globalizing society, and in particular how globalization is challenging the potential of the law to regulate, protect, and solve disputes. So we are interested in studying phenomena that are brought about by globalization, and certainly today's event fits squarely in one of, let's say, the phenomena that are brought about by the globalizing society we live in, and we want to see how these globalization phenomena are reshaping and arguably also challenging the role of law, and also the traditional orthodox functions that the law has to play in a society to regulate public action, to protect the weaker parties in a relationship, to solve dispute, and so on. And we are also interested in seeing how, given the complexities that globalization has brought about, how can and should a sufficient degree of judicial protection and conflict resolution be ensured. Here on the screen, you see a couple of examples of projects that are being carried out or that are almost finalized in the framework of our research network. And I am particularly happy to spotlight the second one, which is on Article 47 of the Charter, because one of our speakers today in the second panel, Caterina, did indeed participate to this project on a topic that concerns, well, also the core of our presentation today, the role of Article 47 of the Charter, the notion of effective judicial protection in tax matters. Now, moving to today's event, what we start from, as you all know, is the notion of foreseeable relevance as a key element of the standard of transparency in tax matters, and also a notion that has undergone quite significant changes in scope and interpretation to ensure both a wide exchange of tax information, but also the correct application of international agreements agreements and domestic tax law. The aim of the webinar today is to reflect on the evolution of the Court of Justice case law from the Berlioz case of, by now, a couple of years ago. I keep on saying the recent Berlioz case, but it's no longer recent, to the more recent Luxembourg cases. And as I mentioned in the beginning, we aim to do that from really not so much a specialist, either tax law or administrative law perspective, but we really would like to combine the various perspectives. And that's also is reflected in the speakers that we have today. We would like to take this strand of case law really holistically to see what this has meant for the notion of foreseeable relevance and how this evolution has shaped the taxpayers' rights. We also are interested in examining, discussing the influence of the OECD and its guidelines on European legislation on the matter. We will also talk and reflect on the influence of Article 47 of the Charter, principle of effective judicial protection, the right to an effective remedy, on shaping the taxpayers' right, access to justice, but also shaping the cooperation procedures that are in place according to European legislation. And finally, we will reflect on how this case law is really shaping, let's say, the horizontal cooperation, the so-called horizontal composite procedures in the European administrative space, and how these composite procedures, this system of horizontal administrative cooperation, arguably still displays some gaps of judicial protection, despite the presence of Article 47, of the notion of an effective remedy, and so on. So with all of this in mind, apologies. So we have a first panel, which is really more focused on the tax law perspective. So after I leave the floor to Marina, we will move to a first panel where we will have first Jasper, who will discuss the influence of the OECD in the creation of legislation on exchange of information, and then Professor Pasquale Pistone, who will really jump right in the notion of foreseeable relevance and how it has evolved over time. After, we will have some discussion and then a short coffee break, unfortunately virtual, I'm afraid. And then we will move to a second panel where first Caterina will discuss the specific role of Article 47 in tax cases. And finally, Felipe will discuss the question of the judicial review or lack thereof of foreign acts in horizontal composite administrative procedures. So having said that, just one final slide before I leave the floor to Marina. The speakers are invited to present for 15 to 20 minutes. And when it is discussion time, I invite the members of the audience to raise their virtual hand so that the chair, Marina or myself, will be able to give the virtual floor to those who would like to add to the discussion. And final point from my side is that the contributions to today's discussion will all be published together with some final reflections on the side of Marina and myself on the blog of the Review of European Administrative Law, together with a recording of this seminar. So thank you very much for being with us today. And Marina, the floor is yours.
Right. Well, thanks, Mariolina. And mainly the role I have here is to introduce you all to the context of the facts of the cases and the questions that reach the Court of Justice of the European Union. And so as to put you in scope before we really get into the analytical content of our seminar that's for our speakers. So I'm basically presenting the cases and what cases I'm going to deal and to explain. Well, mainly three cases. First of all, Berlioz, chronologically speaking, Berlioz. Then we have the twin Luxembourg cases that I think that we can call them the Shakira cases. And finally, the Luxembourg versus L case. So I think that we can go to the next slide. Thanks, Marilena. What happened in the Berlioz case? Well, first of all, Berlioz was a Luxembourg company and was the parent company of a French subsidiary. In 2014, in December 2014, the French tax administration doubted about that the French subsidiary was really complying with the French legislation, entitling it to enjoy an exemption on the distribution of dividends to Berlioz. So for this reason, the French tax authorities sent to the Luxembourg tax authorities a request for information concerning Berlioz. Following this request, the Luxembourg tax authorities sent a decision to Berlioz requesting for that information. However, Berlioz only decided to send part of the information because in its own view, the information that the tax authorities from France were requesting was not totally foreseeably relevant. So in front of this situation, I think that we can, and now that we have the scheme of the facts of the case, we can move forward to know what happened here. So it's like a soap opera. Next slide. So Luxembourg tax authorities sent a decision informing Berlioz that as it did not comply with the obligation to provide the information, unfortunately, they had to impose an administrative fine. Berlioz tried to appeal that fine against the administrative tribunal. However, the administrative and also Berlioz tried to ask the administrative tribunal whether it could pronounce itself to determine whether the information order was well-founded or not. Here, the administrative tribunal upheld part of the main action, decided to reduce the fine on grounds of proportionality, but it dismissed the rest of the action, which means that it denied to pronounce on the validity of the order, because according to the newly in 2014, newly passed Luxembourg domestic law, the holders of information who were required by the tax authorities to communicate certain information couldn't challenge those decisions requiring information. So in front of this context, Berlioz decided to launch an appeal before the administrative court of Luxembourg, because it considered that refusal of the administrative tribunal to determine the validity of the decision requesting the information could constitute a breach on the right to an effective judicial remedy set in Article 6.1 of the European Convention of Human Rights. So in front of this situation, I think that we can go to the next slide. The administrative court decided to refer several questions to the Court of Justice of the European Union. And I think that we can summarize those questions the following way. First of all, the administrative court wanted to know what is the meaning and the extension of the concept foreseeable relevance referred in the Directive of Administrative Cooperation, Directive 2011/16. Then the administrative court also wanted to know whether there is or not a violation of the right to an effective remedy referred in Article 47 of the Charter, the EU Charter, in the following context: when a person like Berlioz, which is holding information, is holder of the information, and on whom a penalty has been applied because it did not comply to provide the requested information, is not entitled to challenge the validity of that domestic order that made the request. Finally, the last question that the administrative court asked was regarding the scope of the control that the tax and judicial authorities can exercise without really undermining the purpose of administrative cooperation of the directive. So I'm going to leave it here, because then our experts of panel 1 and 2 will really deal with the content and the answer of these cases. So I think that we can jump to the Shakira cases, the twin cases. What happened here? Now we go to Spain. From France, we cross the Pyrenees, go to Spain. And some years later, in 2016-17, the Spanish tax administration, or the tax authorities, initiated two different exchange of information upon request procedures with the state of Luxembourg, requesting certain information regarding a particular taxpayer that they called FC. I mean, we can call her Shakira, and which was a natural person and still is a natural person resident in Spain, in Barcelona specifically. So according to the tax authorities of Luxembourg, of course, they had to send the decisions requesting the information to the holders of the foreseeably relevant information, which were Company B and Bank A. And basically, they wanted them to provide information regarding bank accounts and financial assets, which were beneficially owned by Shakira. And they also wanted to know about different types of economic transactions, banking transactions, etc., that might have been carried out by the taxpayer herself and by third parties that we call, the court called C and D, that might have been acting on her interest and on her behalf. So particularly this decision, these two decisions requesting the information, expressly stated that under the Luxembourg law, no action could be brought against such information orders. Of course, I think that we can go to the next slide. In front of that situation, the taxpayer and the third parties affected, C and D, brought a claim before the administrative court seeking basically for a variation or an annulment of those orders. Here, the administrative court partially annulled the information orders on the grounds that some of the information that was required did not comply with the standard of foreseeable relevance for the purposes of the investigation carried out by the Spanish tax authorities, and also on the grounds that the Luxembourg legislation was not really consistent with Article 47 of the EU Charter, and which means that they shouldn't really be applying that legislation. Consequently, the Luxembourg state made an appeal in front of the higher administrative court, and here the higher administrative court decided to ask some preliminary rulings to the Court of Justice of the European Union again, and this time regarding the, I think that we can, no, it's here, the questions are here. They asked regarding the concept of foreseeable relevance. They wanted the court to pronounce on the scope of foreseeable relevance, but specifically regarding the invoices and payments. And on the other hand, here the higher administrative court wanted to know whether Article 47 of the Charter really precludes national legislation that excludes, first of all, taxpayers concerned by the tax investigation. Second of all, a person's holding information like Company B or Bank A. And finally, third parties concerned by such information like Company C and D from bringing a direct action against the information order. So this is the state of the art in the Shakira cases. I think that we can go to our last case, our last Luxembourg case, which is Luxembourg versus L. What happened here? What is the context here? Well, also in 2017, here we go again to the other side of the Pyrenees, we go back to France. The French tax authorities sent to the Luxembourg tax authorities a request of information regarding a property company called L, located in Luxembourg, because it was an indirect parent company of F, also a property company located in France, which was being investigated by the French tax authorities. Both companies, L and F, owned some real estate, some movable property in France. And according to the French domestic law, they had to declare it. So what did the French tax authorities wanted to know? They wanted to know the identity of the shareholders and beneficial owners of Company L of Luxembourg. So they sent the request of information. Accordingly, the Luxembourg tax authorities sent a decision requesting that information to Company L, and L appealed that decision. However, what happened, if we recall the other two cases, according to the domestic Luxembourg law, they couldn't appeal those requirement of information decisions. So the appeal was declared inadmissible, and the tax authority sent L another decision informing that as it had failed to comply with the information order, unfortunately, another penalty has to be imposed, but this time on L. So in front of this situation, I think we can go to the next and final slide. No, not final yet. L brought an appeal and brought the case before the administrative court in order to also modify or annul the penalty decision. And here also the administrative court ruled in favor of L. And it annulled the decision because it considered that the investigation was being issued on F, which was a taxpayer in France. However, the information required was in fact about L's shareholders and beneficial owners, and therefore there was no foreseeable relevance on that sought information because the information required was not really linked to the investigated taxpayer, which was F, the French one. So consequently, Luxembourg state again lodges an appeal before the higher administrative court, and here the higher administrative court said that, all right, since the shareholders and beneficial owners of L are ultimate beneficial owners of F, which was an indirect subsidiary of L, there is actually foreseeable relevance on the information requested. However, the court detected another thing here, and it detected that the request from the French tax authorities didn't properly identify individually, on an individual basis, the name who were the shareholders and the beneficial owners of L. Even though the higher court knew, and this is a spoiler of Berlioz, knew that in Berlioz, the Court of Justice of the European Union understood the concept of foreseeable relevance as it reflects that one used in Article 26 of the OECD Model Commentary and Model Convention and its commentaries. Even though that, and even though knowing that the latest updates of the OECD commentaries stated that when there is a request of information regarding a group of taxpayers who are not individually identified, this request may meet the standards of foreseeable relevance whenever the target of the investigation is really a limited and narrow group of persons. So in front of this situation, the higher administrative court really doubted about how to interpret the directive of administrative cooperation regarding the requirement of identifying the group of the taxpayers. So here, and now, yeah, last slide. Thanks, Mariolina. The higher administrative court asked the following questions to the Court of Justice of the European Union. Well, first of all, regarding the concept of foreseeable relevance, it wanted to know which has to be the content of the requirement to identify the taxpayer, and regarding a group of taxpayers, which should be the criteria to comply with the standard of foreseeable relevance under the directive. A second type of question was also regarding, again, on the scope and extension of Article 47 of the Charter. However, they asked about interpretation of Article 47 in a situation which was essentially the same one as in Berlioz. But this time the higher administrative court wanted to go a bit further and asked, it wondered if the legality of that same situation is recognized by the Court of Justice of the European Union, whether a taxpayer like L should be granted then a reasonable amount of time in order to comply with the information order to provide the requested information. So these are, in summary, the facts of the series of cases that help to shape the notion of foreseeable relevance and also to shape the extension of Article 47 of the EU Charter on tax cooperation, cooperation for tax matters. So I'm going to leave it here. Now I'm going to pass to the first panel. And as Mariolina said previously, this first panel is going to analyze, first of all, the impact and the influence of the OECD, as we could saw in the cases, in the facts of the cases, the influence of the OECD in the interpretation of EU legislation, specifically in exchange of information procedures for tax matters, and also how the concept, the notion of foreseeable relevance has evolved and what is and has been its impact on the taxpayers' rights within the EU. So I'm going to introduce you to our experts in this first panel. Let me start with the first speaker. The first speaker is Dr. Jasper Corbin. Dr. Corbin is a senior manager in Deloitte's Tax Research Department. He has over 18 years of experience and is specialized in EU tax law and international tax issues. Besides his work in Deloitte, Jasper is also assistant professor in Maastricht University, where he defended his PhD titled Internal Market Neutrality, which was defended in 2017. Dr. Corbin is also involved in all kinds of actions within which the EU law plays a role, and both related to EU policy for tax policy and case law of the European Court of Justice. And he's also involved in EU-related litigation. Also, Dr. Corbin is part of the EU Tax Eminence Group, which contributes to a better understanding of the European case law and its legislative developments. And during the last years, like from 2019, 2021, he has acted as secretary of the Seminar on European Tax Law for the Congress of the IFA. He's well-known contributor for specialized reviews, both in English and Dutch, and he regularly speaks in conferences like our one that we're holding here. Our next speaker is Professor Pasquale Pistone. I think that Professor Pistone, for those coming from tax law, really doesn't need introduction, is very well known. But for those of you who don't know him, he's the academic chairman of the IBFD in the Netherlands. He's full professor of tax law at the University of Salerno in Italy. He is a holder of a Jean Monnet ad personam chair in European tax law and policy at the WU, the Wirtschaftsuniversität in Vienna, Austria. He's also professor honoris causa at the Ural State Law University in Russia, doctor honoris causa at the University of Örebro in Sweden, and honorary professor at the University of Cape Town in South Africa. He's co-director of the IBFD's Observatory for Protection of Taxpayers' Rights, co-chair of the Tax Committee of the International Law Association. He is also a secretary of the executive board of the ETLP, the European Association of Tax Law Professors, and member of the permanent scientific committee of the International Fiscal Association. His contributions to tax law have been translated and published in 12 different languages, and he's editor and co-editor of several recognized reviews in tax law. And I would never end, Pasquale, if I continue with your CV. So it is, as I said before, and you said don't exaggerate, yeah, it really is an honor to count with your presence in our humble seminar. So now I'll leave the floor to you, starting with Jasper. So yeah, the screen is yours. Thank you very much.